names will be released, then this will just be all propaganda.
You mean the names of the victims?
Yes.
Well, I think this is a clear misunderstanding. Before the court, victims participate anonymously. I mean, the court is very aware that victims live in places where their life can be still in danger. And the only possibility for the court to provide safety and security to the victims participating is to call them with a number. And this is the reason why yesterday, when we discussed our presentation, we did not mention on purpose the names of the victims in order to avoid to expose them to danger in the places of threat, in the places where they still reside.
But I mean, you can tell the camp of Duterte that these victims are real people.
Yes, of course. But when a victim applies in the proceedings before the court, there is a form. In that form, they have to describe what happened with their names, of course, right? Then this form is given a number. And in the proceedings, victims are known with that number. But the application form is available to the judges, so they know exactly to whom we are referring when we speak in courtroom and we stand for the victim. So these are not, as the defense was trying to explain to us, pictures in reports. These are real people. These are people who still continue to bear a lot of consequences of what happened to their families, to their loved ones. So, and this is the message that we would like to pass, and that we hope we have passed in the last 2 days, and that we will pass in the coming days at the confirmation and beyond.
Paolina, does the defense also know the identities of the victims? And if yes, have they been given security detail just so they wouldn't face any retaliation back?
No, normally the application form is not provided to the defense and the prosecution. By the way, there is only one exception when a victim is also a witness. Because as you can imagine, a victim is the person who first suffered the event, so it's a real witness. And yesterday, you have probably seen, you have heard Mr. Jeremy and Mr. Croft mentioning some of the witnesses. Some of these witnesses are also victims who participate in the proceedings. This category of person is called in the ICC proceedings dual status individuals, because they accumulate the status of participating victims and of witnesses for the office of the prosecutor in this case. If someone has this dual status, then the application form of this person has to be provided to the defense. In any case, there is no prejudice for the victim because the defense already knows the identity of that witness. Of course, details of the whereabouts of the person are not provided, but this is also for any witness by the office of the prosecutor, by defense, or any witness that we will eventually call. So they know the identity of certain of the victims because certain victims are also witnesses for the office of the prosecutor, and there is an obligation to disclosure this element to the defense.
The victims whose stories were specifically mentioned by you, by all three of you in the opening statements, how are they after they've just heard their stories told to the world? Have you spoken to them? How are they dealing with this?
Well, to be frank, for security purposes, I've not yet contacted that specific admitted victim. But generally speaking, the victims are actually exhilarated. They were happy, joyful that we were able to impart their stories. They're real human beings with real family members who were murdered, and that their plight, especially their marginalized state, was fully stated before the court. So I think it's important for them that that was conveyed to the chamber. And also, I'd like to answer the previous question. Context is very important. The context here, international crimes. These are crimes, mass atrocity crimes. Therefore, there's actually a heightened security risk for the witnesses. So there's really this very important principle, the do no harm principle. We as lawyers, we have that duty to protect their identities. Second, even in the Philippine context, there are instances wherein the complainants, victims' names are never stated even in the court title. For example, anti-child abuse cases as well as rape cases. So it's actually not precise to say that this is mere propaganda. These are the truth, and these are actually admitted victims whom we quoted before the chamber.
Aren't they supposed to know that? They're lawyers.
Yes, because something that sometimes maybe the defense forget, or people who are not familiar with the ICC system, is that before someone is considered participating victims, there is a judicial decision. So the victims apply with an application form to the registry of the court, explaining what happened to them. All these forms are provided to the chamber, and the three judges make a judicial decision on their participation. So it's a judicial decision. It's not that anybody applying to become a victim is a victim. The judges make a decision. And on what they base the decision? They base their decision on the document containing the charges. So they look at what the prosecution is alleging in the document containing the charges, and then they verify in the application form of the victims if the victims is a victim of one of the alleged charges in the document containing the charges. If the answer is yes, it means that the person can show the actual link between the harm suffered and the alleged charges and can be authorized to participate. As you know, the charges at the moment includes murder and attempted murder. But as you have heard yesterday, other crimes were committed in the context of the so-called drug on war, including rape, sexual assault, torture, inhuman treatment. We make a small reference to that in our speech, because otherwise we will not have described the totality of the victimization suffered by the victims that we represent. Unfortunately, before the court, the proceeding is very often limited by a decision of the prosecution about the charges, and they decided only to bring these charges. It doesn't mean that us, as lawyers, we cannot also inform the chamber of other events that had an important impact on the victims and on the consequences of these events. And why I'm saying this? Because it means at the moment we have 487 victims authorized to participate, which you think, sorry?
What's the disparity between
For
487
actually,
and 539?
I wanted to ask that.
Combien? Okay, 539. There was, we have to explain why. Because in the Philippines, victims were able to file individual forms and household forms. And the household forms, there was a discussion for certain of them on how many family members were actually signing the form. So, and we received confirmation from the registry, so we can confirm that is now 539 victims authorized. Which you compare what we have heard in the last 2 days, it's not a huge number, right? Yeah. Because we are speaking of thousands. Well, this is explained for different reasons. First one, victims are still afraid in many locations to come forward. Second, there was a procedural issue in relation to the facts of whether or not the charges included events throughout the Philippines. And this has been confirmed by the prosecution only few weeks before the confirmation of charges. So not all the people who could be interested throughout the Philippines were able to apply. Also because the chamber put an end date to the possibility for victims to apply. This does not mean that victims will not be able to come forward, because if the charges are confirmed, then victims will be able to continue to apply in order to be authorized for trial. And we hope to also be able to incentivize victims to come forward if there is a trial.
Can you tell us briefly about the process on how victims can apply? Is this online, since many of the victims' family are from the Philippines?
Yes. There is a specific section within the registry of the court, which is called Victims' Participation and Reparations section. This is a section which works together with public information to outreach to the victims' communities and explain to them that there is a proceedings, that they can participate, what does it mean to participate in the proceedings, which rights victims have. Then, of course, the choice is always individual. You can feel or not feel to participate in a judicial proceedings. If someone decides that they want to participate, there is a form, which is a form of only 2 pages available. This form is available on the ICC website. It's also distributed in the Philippines by a number of NGOs who are also working with victims and knows victims' communities. Victims are supported in completing the application form. They can do alone, or they can help someone, for instance, one of us or someone in the NGOs to help them complete the form. And the form, if you look at it, it's very easy. You have to put your identity, when you are born, your nationality, which language you spoke, which is your family status, if you have children, if you have a job, and then you put the account of what happened to you. A victim does not have to identify the perpetrator. That's not the role of a victim. They have simply to say what happened to them, and then there is a second part of the form in which they have to say which are the consequences of what happened to them. And this second part is important because if at the end of a trial, the accused is convicted, victims can trigger a reparation proceedings. So the description of the harms already could help not only to explain the victimization to the judges at trial and the background, but also to build observation for the future in reparations if we will arrive to a reparation process. This form has to be signed, and then the person has only to include an identity card to prove the identity. The threshold for the application form is very low. We call it a prima facie. So it's a very low threshold. Victims have simply to show that they had an harm because of a crime, which is under the document containing the charges. That's it. And then it's for the judges to decide.
So there will be no assessment of the veracity of their claim, or how do we?
Normally, first of all, I would like to state very clearly that in all these years, the court never had an issue with the veracity of the application forms of victims in any of the situation and cases before the court. I think this is important to state it. Second, when the judges proceed in evaluating the form, they will evaluate the way in which the victims explain what happened to them. If the account is credible, if it's actually corroborated by what is in the case record, if it's coherent, and on the basis of these elements, the judges are able to make an assessment. To give you an example, not all the victims who apply to participate at the moment have been authorized. For some of the victims, there are information which are missing. So these victims, it will be our task later on to contact them and to help them to provide more information so that their application can also be considered completed and considered by the judges. What I mean is there is an inherent power in the chamber to verify the application compared with the document containing the charges and the document in the case record.
But is 539 the final number?
For the participation at the confirmation, yes, but the process of application will be reopened as soon as we will know a decision on the confirmation of charges.
So basically, if they decide to pursue the confirmation of charges, the application can proceed and add
Absolutely,
to
yes.
the 539 victims. But right now, it's closed.
Yes, at the moment it's closed, but the process will be reopened once we will have a decision on confirmation.
Just to summarize what you said, Attorney, basically, so it was really the judgment of the ICC judges in comparison to the documents containing charges, if they were going to be admitted as
Absolutely,
victim
yes.
participants. Hence, they came up with the 539. And your role, was it to vet them or not, the 539?
No. What we do as lawyers, victims can present application with a lawyer or not. In the 539, you have people who simply individually presented their application without a lawyer. Others, they were already assisted by Filipino lawyers or other lawyers. So it depends. But normally what a lawyer does is to listen to the story and help the victims to write that story in the form. Of course, we have also a role of advisors because we need to speak with the person, understand what happened, and we can advise, okay, did you remember the date or not? Are you sure of that? So if a lawyer is implicated in the process, but of course, maybe the application is a little bit more detailed because we are more attentive to these kind of issues, but it's not necessary for a victim to have a lawyer to present an application before the court.
By judicial decision, you mean that 3 judges of the chamber can certify that all of these people are real, the victims?
Yes, of course, because they have to prove their identity. If you do not prove your identity, your application will be considered incomplete, and therefore the judges will not issue a decision on the merit, I would say, of the application.
We keep saying from the prosecution to your team that there are thousands of victims actually from the widespread killings. But is it necessary to actually prove that in this case, that there are thousands? Because the other team keeps on harping on the inconsistencies in the figures.
Well, no. There is no obligation from the prosecution to prove the exact number of a victim. This is a standard jurisprudence at the court. Consistently, chambers of this court has indicated that there is no obligation to prove the number of victims affected. Because when we speak of international crimes, by definition, these crimes entail a huge number of victims. What the prosecution will need to prove is that all the incidents that they are including in the document containing the charges, that for all these incidents, there is enough evidence to commit Mr. Duterte to trial. And this is the reason why, for instance, yesterday, the prosecution focused on the different counts. If you remember, they said on count 1, I will present the evidence on count 1. On count 2, I will present the evidence on count 2. So, and this is the way in which they proceeded, because they need to show to the chamber that there is enough evidence showing substantial grounds to believe that these crimes were committed and were committed by Mr. Duterte.
And in what way will the accounts of the victims, especially those that you presented, help the presentation of the prosecution? You mentioned that it will corroborate.
Yes.
Right? But of course, we had a preview of the arguments of the defense saying that, no, there's nobody who is able to prove that the orders actually came from the president. I mean, the victims did experience this and that. But where is the order from?
I think we need to understand a few things here. The first one is that the burden of a proof rests on the prosecution. What lawyers for victims do, they help. First of all, we are completely independent from the prosecution, and we represent the voice of the victims. And I think that it's important to stress that, because very often victims' lawyers are assimilated to the prosecution or called prosecution bis, a second prosecutor. This is not the case, because victims very often, they have very different interests from the one of the office of a prosecutor, starting, for instance, with the charges brought before the court, which the victims consider being very limited in respect to their victimization. So this is one important thing. The second is the victim account really corroborate what the prosecution has presented, in the sense that if you remember the few quotes that we read yesterday, these quotes actually are exactly the same of what prosecution witnesses are saying as well. So there is a form of corroboration in this sense. And what I think it's also very important is that victim can provide much more details and evidence on the background of the crimes. The intervention of Mr. Andres, of Gilbert yesterday, was very important, because he looked at the Filipino perspective, explaining very clearly how these people were affected by the crimes. And this is a perspective that you will never get from the prosecution, because they don't know enough the Filipino background. And I think this is also the richness of a team composed of Filipino lawyers and international lawyers, because we can really complete ourselves and be sure that the voice of victims is really heard the way they want their voice to be heard. I don't want to monopolize, please.
I wanted to add the evidence that would be needed to convict Mr. Duterte would be like a jigsaw puzzle. You would have the victim witnesses who will testify on the specific crime committed against their loved ones. You don't expect them to testify, pointing to Mr. Duterte. You have to weave it together with the evidence of the insider witnesses who will say that there was this plan to really use killings and violence. And then you weave it again to the statements of Mr. Duterte saying that I will protect you, so and so. So,
You have heard yesterday and the day before an important word for us, which is insider. The insider is someone who was in the circle of Mr. Duterte and who became a prosecution witness. So, and you have seen some quotes, no, of these people. I was recruited and then I had to kill. I'm using recruiting into brackets. There was a quote of someone who was explaining, no, you need to be cleared. So we could only kill if the killing was clear. And the question was, what, clear by who? By Mr. Duterte. I didn't fear anything because it was clear by the president. There was one of the quotes yesterday during, I think, Mr. Jeremy presentation. So the proceedings is actually two-folded. On one side, you have all the information coming from the inside that can indicate to the orders, the chain of command, how it worked internally, and how the common plan was designed. And on the other side, you have all the part of the victimization. And these are the two components of the proceedings before the court.
Attorneys Joel and Gilbert, the prosecution yesterday was saying a lot of things about how neutralize meant to kill. And that's the very same thing you were arguing in the Danyo petition, what was going through your mind? What could the Supreme Court have done? What would the impact if there was a Supreme Court resolution of what neutralize actually means? Especially that Kaufman was saying neutralize is just metaphoric.
Subject to interpretation.
Well, I think there are so many police statements, no, that you can call the meaning of neutralize as a language used by the police, and it's really killing and
Eliminate.
elimination, no, physical elimination. That's, I think, very clear in the parlance of the police.
Would a Supreme Court resolution have helped if they defined what neutralize was, if they found neutralize meant to kill?
It would have helped, yeah. But I remember when we were arguing the Supreme Court in the Danyo case, that was actually raised by Justice Carpio. He raised that particular point, and he said that in the parlance of the police, and he cited some, if I remember correctly, he cited some materials, written materials from the police itself, that neutralize means killing.
And there is jurisprudence, by the way, at the court in relation to these kind of terms, because neutralize, it's not the first time that it is being used. We have other, in the Lorang Babo, it's not a good case, because at the end they were acquitted on appeal. But in the Katanga case, for instance, in relation to the order given, there is jurisprudence of the court on the interpretation of these kind of terms, which are normally interpreted in the context in which they were pronounced. So it's not, because neutralize, I mean, if I have a mouse in my house, okay, I can now neutralize the mouse. I think it's a good idea to do it, right? But if I start speaking of neutralizing, I target, and you read that with all the public statements in relation to I am the person who will kill everybody who is dealing with drugs. I'm doing it for your country. This is what I watch you. I mean, there are a lot of elements that needs to be read together. And I think this is also something which is important. At the court, the judges will read all the evidence together and holistically.
Right.
And they will interpret that evidence the way in which it's most reasonable to understand. And this goes also to the term neutralize, in my opinion.
All right, for the two Filipino lawyers, I'd like to ask, how do you respond to the defense claim that Duterte's statements were only rhetoric or bravado?
Hyperbole.
Well, number one, Mr. Duterte is a lawyer, he's a prosecutor, so he actually knows the legal consequences of his statements. These are actually admissions, and he knows that. Number two, the President of the Republic of the Philippines is the executive. Therefore, whatever statements he makes in public, they're not merely rhetorical, they're policy. And the fact that he stated explicitly that killing was, in fact, encouraged and even commanded by him, that's already indicative of a state policy by Mr. Duterte. Let me also tie that up with the question before. In fact, in the Danyo case, there was a resolution. It's not the decision, but there's a resolution, if I'm not mistaken, April 2019, wherein the Supreme Court there referred to the 2017 government report stating at least 3,000 deaths under police operations. And if I may paraphrase the Supreme Court resolution, the Supreme Court stated that this seems to indicate that there's a policy of extrajudicial killings.
Moving forward, of course, on Thursday we expect to hear the defense. What do you think will be said there? How can they dismantle the evidence of the prosecution? And what if they bring up the issue on jurisdiction? Do you expect that also?
The issue on jurisdiction is already on appeal, no? So they
Yeah.
cannot raise that because the pretrial chamber has already rendered the decision.
Yeah.
Yeah, on
Kaso
the-
sir, they parang they make an issue out of it. it's like they said that we are forced into a confirmation hearing while an important issue is on appeal, which is the jurisdiction matter.
Two answers.
Yeah.
Number one, any appeal before the appeals chamber does not have automatic suspensive effect.
Yeah.
There's a separate application for that. And the clear fact is the defense has not made any application for suspensive effect. Number two, therefore, if there's no suspensive effect, it was not applied for, then the proceedings before the trial chamber should continue because, in fact, there was a decision by the pretrial chamber that it has jurisdiction. Third, if you look at all of the case law of any international criminal tribunal, there has never been a case law that states that this international criminal tribunal has no jurisdiction. You can go as far as prosecutor versus Eichmann. You can go to the ICTY in the Tadic cases. Never been. And if we just follow the jurisprudence, then I think jurisdiction will still hold for this court. And fourth, I think those statements were really political statements. I think, to be very frank, it's for the Filipino audience.
And we had a preview during the opening statement of
Yes.
Kaufman, right? He vowed that he will dismantle the argument that he made those
The
orders by saying that, because the prosecutors cherry-picked, and
Yes.
there are parts of the statement
Yeah.
that actually exonerates the president.
Well, we will hear probably arguments because he anticipated that he will go also to challenge the published statements indicating that what has been interpreted by the prosecution is actually not what the statement was saying. We have heard this in their opening, so we think that we can expect their arguments. What I think it's important on our part to stress today, particularly for the victims, victims will hear tomorrow and the day after tomorrow very unpleasant things, okay? Because the defense will try to challenge the prosecution, saying nothing is true. Now, what I think it's important to say is that this is a judicial process. If you play hockey or football or any other sport, we play following the rules of that game. Here we play following the rules of a judicial proceedings, which means that the prosecution has a theory, we support that theory with more insight from the victims, the defense has a contra theory. So the defense will say nothing happened. Mr. Duterte was a good president. He was trying to make the Philippines a more rich country. He was trying to make the Philippines a more safer country. And we can show with other evidence that what the prosecution is saying is false. So victims need to know that this will happen, but they do not need to be afraid or worried. I think this is important to say for them. They need not to be afraid or worried. This is the way in which things are discussed here. On my part, I think we can say, we can agree that we are confident about the evidence presented by the prosecution. We think that the prosecution has a strong case, and we think that the victims should be confident in the judges and in the court role in acknowledging their sufferings.
What kind of testimonies you think or witnesses will they present tomorrow, or at least even quote tomorrow to defend the former president to any of the lawyers?
Well, Mr. Kaufman already said that he's going to cite multiple statements of Duterte saying that he ordered the police to follow the law, that they're going to be liable for their... But, look at the context. When Duterte said these statements, hundreds, thousands were dying, and no investigation was ever made with respect to all these multiple killings while he was saying these statements. So what's important is, were they doing any kind of investigation? There was none. It's very clear in the police regulations that for every death, the police should subject themselves to preliminary examination. But in almost all the cases that we handled, the police did not. subject themselves to preliminary examination.
But are you expecting quotes from actual witnesses for the defense, as what the prosecution and the CLRV did?
They don't need to do it. We don't know. I mean, we know, I think we can imagine the strategy because they said it, but for the confirmation of charges, actually they don't need to
Yeah.
present witnesses. So it could be that they will not. My impression is that they will focus mainly on the fact that there were no order and that the intention of Mr. Duterte were misrepresented by the evidence of the prosecution. This is what I think they will do.
Attorney Joel, in your opening statement, you really dedicated a lot of time addressing the Duterte fans. You call them worshippers, fanatics, mini Dutertes and clones. Why was it so important for you that you focus on that in your opening statement?
So, because I wanted the judges to really know that the impact of the crimes are still happening up to this time. And it affects the willingness of the victims to come out and participate in this case that's ongoing in the ICC. Because it's very important that the court should know that the crimes did not freeze in its effects during the time of the killings, and it's still ongoing up to now.
I'm just curious, having worked on the drug war with the drug war victims since day one, how was it like being straight, directly facing Kaufman as he says, you lied, it was propaganda, it was the collusion of the media, the lawyers, the NGOs, yet you know you have seen and worked with victims for the last 10 years?
Well, the first thought that came to my mind was I wanted the trial to begin as soon as possible so that we can debunk everything that he said.
To follow up.
Well, we were a little bit disappointed when Mr. Duterte was not appearing actually, and because the public version of our response is out, so you can read it. But for the victims, it was very important to see him standing before the judges. So for us as well, it was very disappointing. For me, yesterday, it was very emotional.
He submitted another waiver for the detention hearing. How
Ah.
are you reacting to that? Yeah.
Well, they will probably going to get it. So yeah.
But that's extra disappointing.
Yeah, this is extra disappointing, I think. I think that there were enough arguments for the judges to order his appearance. As we have said repeatedly, the fitness, the experts have indicated that he is fit to come, and the judges even adjusted the schedule of the hearing for him to be able to be more comfortable in following it. So it was a little bit, for me at least, and I think for all of us, it was very disappointing. But we have heard from the victims as well, because it was their opportunity to see him for the first time in a courtroom of law facing the judges. We need to understand the symbolism of that. It's symbolic, but for the victim, it's already very important to start somehow healing, because it shows them that they can have confidence in a court of law.
Yeah, to follow up on the question of Lian, in your statement yesterday, while the proceeding should be based on facts and evidence, you were mentioning about the systemic marginalization of the poor in the Philippines and how this drug war affects the very poor and marginalized people in the society. Also with the statement of Attorney Joel and Gilbert, you emphasize that this is not just about killing people, but this is about the society and humanity as a whole. Although facts and evidence should be presented, but how will this be making a point, like, when you're playing football, it should be a goal.
I think this was essentially done. We discussed this because of a background, and because when we speak with victims, for them it was not a war against drug. It was a war against them and them as poor people, because they could be used by the authorities to do whatever they wanted. And this is a message that we heard very clearly from them. So it was, and if you look at the documents, no, the Duterte war on drugs, everywhere this proceeding is labeled as relating to the Mr. Duterte war on drugs. For victims, wasn't there. For victims was more how they lost their humanity, as Andres said yesterday, how they lose their dignity, how they were not even considered as human beings. And I think this is important to understand, because this is part of the context of the attack against the civilian population. So this background can actually be used to reinforce the chapeau, the elements of the Article 7 that you need to prove, particularly the attack, the systematic and widespread attack against the civilian population, and the reasons why that specific civilian population was targeted.
Mr. Kaufman was sounding like a DDS himself, using political messaging in his opening statements. Is that an indication that they have a weak defense and have no evidence should the case proceed to trial?
Well, he labeled my presentation, my opening statement, as political demagoguery, but if listening to him, he was practically presenting the defense that the case in the ICC is a conspiracy of the BBM administration. He is imputing a conspiracy between the BBM administration and the ICC. But the investigation here in the ICC started in 2018. Who was the president at that time? It was Duterte. And the preliminary investigation started in 2021. Duterte was still president. So it's his presentation actually which is political, because he's insinuating that, and Duterte and the Marcoses were together in 2022. So it's his presentation that's actually political.
But if Mr. Kaufman felt compelled to respond somehow to Mr. Butuyan, I think it shows that Mr. Butuyan had a point, actually, because otherwise you will not take your time to respond. So we can probably also expect some responses tomorrow of what we said. Coming back to what we can expect, he will probably use some of our arguments for his purposes as well, which is normally what happened.
Right.
So this could also be.
Yeah.
Lastly, you mentioned that the victims should prepare tomorrow because it would be really painful for them. And how are they preparing now? Because your clients are the victims. And secondly, for sure they will be again dehumanized. That they the defense would repeat again dehumanizing words, definitely against the victims.
I think we've prepared them in the sense that we stated that this is a process. This is merely the first step towards their right to truth and justice. There will be many steps ahead. And we're actually trying also to manage their expectations. And we are frankly telling them to pray about this process, because we also need guidance for this process. So they're mentally prepared. Why? Because they've waited for this for the past 10 years.
And also we will have, in any case, the opportunity in closing arguments to respond also to some of the arguments, because now the defense will present, and then there will be the possibility on Friday, first for closing arguments by the prosecution, closing arguments by the legal representative, and then the last word to the defense. But we still have the possibility to counter-argue to what we will hear tomorrow.
Attorney Jo, just lastly, I think your toast last night was very moving. If you could repeat it, you were saying that you're seeing the light at the end of the tunnel. last time. What does this mean for you having reached this far in the ICC?
Yeah, because we were really involved in helping the victims, capacitating them, documenting the harm, the violence that they suffered as early as 2016. And we filed the first case against the drug war in the Supreme Court in 2016. So we've been with the victims since the beginning of the drug war. And in the beginning, it was really difficult to see the light at the end of the tunnel because there was 6 years of the Duterte administration. But we just continued because we thought that it's important. Along the way, it could be used for the documentation that we were making, either for a judicial process or for historical purposes, just like what happened in the martial law years. And then 2022 happened. There was a unity between the Marcoses and the Dutertes. So again, we couldn't see the light at the end of the tunnel again because we were looking at another 6 years. No? So it was really difficult. No? So when there was a big fight between the two families and the arrest was implemented, it was really a big sigh of relief for us. We immediately saw the end of the tunnel, and now we are here. In fact, it was I was comparing notes with Attorney Colleen, and we really felt surreal. No, the first time that we were here, we were going to attend the confirmation hearings. We felt that it was really unreal that this was finally happening. No? So you could just imagine the feelings of the victims' families. The relief that they're experiencing that this is happening.
Just one last from me regarding the detention. Of course, I assume you will continue to push for him staying, right? And can you just briefly tell us, the arguments again, why this is important for the victims?
For detention, there are no changed circumstances. So it should be the status quo, remain in detention.
All right.
And it's important for the victims because imagine you know that someone did something to you and you have been waiting for justice since a long time, and that suddenly you are faced with a possibility that this person that you believe did you something wrong can be released. So just imagine the feeling. Don't know to find an example. A mother, your mother, okay? Your mother, you're doing something which is wrong, and your mother is telling to you, I can't find now an example to compare, but think of how must be difficult for someone who still bear the consequences of that crime in the soul, not only in the body, but in the soul sometimes in the body if they survive, but particularly in the soul, how must be difficult to be faced with the possibility that the same person is released and is free. Because for a victim, the fact that he is in detention is already something showing that they can arrive to justice. But if a person is released, well, for them, maybe their trust will be somehow disrupted, if I can put that way.
Thank you.
Thank you.
Thank you.
Can I ask something about the reparations? Hypothetically, if a suspect becomes accused and the accused becomes convicted,
Yes.
so who will be in charge of providing reparations, monetary reparations to the victims? Is it going to be Duterte or like a trust fund?
Okay. Normally, if the person convicted has money, the obligation is under the person convicted.
It will be enforced?
If the person is declared indigent, meaning that the person has no money. Then at that point, at the court, there is an entity which is called Trust Fund for Victims. And the Trust Fund for Victims is also in charge of implementing reparation orders issued by chamber. But the liability, and this is clear in the jurisprudence of the court, the liability is for the persons convicted. So for instance, if you take the Ongwen case, in the situation in Uganda, the chamber said Ongwen is liable for thought money. But because Ongwen has no money, then the trust fund will step in. The court has the possibility of enforcing seizure of goods of a suspect as well. This is a process which is confidential within the court and which is normally activated by the Office of the Prosecutor in coordination with the registry. So we do not know at the moment if anything could be available, but we know that the court has the possibility through the registry to identify if Mr. Duterte has goods that could be eventually seized for the purposes of reparation in the future. We have one case in which this happened, and this is the case of Bemba, which was a case concerned atrocity in the Central African Republic. In that case, Bemba had some goods that were seized by the court. At the end of the proceeding, Bemba was declared guilty by the trial chamber, but acquitted by the appeal chamber. So, of course, we don't have then any subsequent actions in relation to that. But it is possible in the framework of the court to look and seize goods from the suspected/accused person and eventually use that resources for reparations at the end of the trial if there is a conviction.
Thank you very much.
Okay.
I think I have a question.
Oh, yes.
I just came from the live report. Wait, let me finish this. I'm so sorry. For Ms. Paolina, how important is this case or what message does this case send to other leaders accused of human rights violations?
I think what we said yesterday also in our presentation, both in the opening and in the presentation of the merits, that nobody is above the law. And also that the court has a mandate and a role, and that the court will fulfill that mandate and that role, independently of how much time it will take and how much difficult could be.